Yesterday, as Americans across the country waited for the highly anticipated decision on the Dobbs case, which we'll still have to continue to wait for, the Supreme Court issued its ruling on another major case that was celebrated as a great victory for religious freedom and for school choice. The case is Carson versus Macon, and the Supreme Court ruled 6-3. And in fact, it was the Chief Justice that wrote the opinion. They said it was unconstitutional for the state of Maine to exclude otherwise eligible private schools from a student aid program simply because they were religious. Now, what can we expect this to impact in terms of educational choice, religious freedom? Well, here to talk about this ruling is Lea Patterson, counsel with the First Liberty Institute, and was the lead attorney in this case. Lea, welcome back to Washington Watch.
It's a pleasure to be with you. Thank you.
First, congratulations. A major victory and a job well done.
Thank you so much. We and our co-counsel at the Institute for Justice are so excited to see it come about.
So give our viewers and listeners a quick background on this case.
All right. So Maine has many school districts that cannot make their own public high school because there aren't enough students who live in the district. So for those families, the state will pay tuition up to a certain amount for those children to attend the public or private high school of their choice, unless that school is a religious school, at least until yesterday when the Supreme Court struck it down.
And so in this case, all things being equal, the only difference was that it was a religious school. Is that correct?
Yes, that's correct.
And so the Chief Justice writing the opinion said that doesn't work.
Nope, that is religious discrimination and it violates the free exercise clause.
So what will be the implications of this? Because this is not the first. We've actually seen a series of religious liberty cases revolving around education going back to 2017 when a Missouri law barred churches from material for a playground. They ruled in favor of the church. Then we had a case out of Montana dealing with school choice. So what is this? What is this telling us? What will be the practical implications of this case?
Well, the practical implications are that if a state has a school choice program, and it doesn't have to have a school choice program, but if it does, it cannot exclude religious schools from being an option under that program. And it doesn't matter if you classify the discrimination as religious identity-based or because it would involve a religious use of funding, it's both religious discrimination that violates the Constitution.
I mean, this could be quite big, Lea, going forward, because as so many parents are fed up with public education and are leaning in on their elected officials at the state level, if we see school choice being advanced, that means that just because a school is religious, it can't be left behind or excluded.
Absolutely not. Parents are free to choose.
From a standpoint of religious freedom, and we've got another big case First Liberty is involved in, and that is regarding prayer by Coach Kennedy. Are we seeing a court that is reestablishing a better understanding and application of the First Amendment when it comes to the free exercise clause?
I think we're definitely seeing good progress on the free exercise clause. It's definitely a strong clause and it protects religious liberty throughout the country. So, the Supreme Court could do anything, but we are hopeful.
Not everybody's happy with this. We see ACLU and the Humanist Association and even the National Education Association concerned about this because this could, quite frankly, break their iron grip that they've had on children across this country in the public school system.
Well, while I would not bemoan that in any way personally, I think the important point here is that Maine already had a school choice program. This doesn't take any money away from the public schools. There aren't any public high schools for these children to attend.
Yeah. But again, it goes back to the fairness. If they're going to let one institution do it. They can't exclude another just because it has a religious foundation or a religious association. So I think
That's right.
it was interesting in the opposition to this coming from the court was that they were concerned that they were more concerned about the Establishment Clause as opposed to the Free Exercise Clause. So it looks like we're moving back to more of a balance between those two fundamental elements of religious participation or religious exercise in this country.
Well, it's important to note here that the Supreme Court already declared almost 20 years ago that allowing religious schools to participate in school choice programs doesn't violate the Establishment Clause. So a state cannot make up an Establishment Clause interest that doesn't exist in order to justify religious discrimination.
But in effect, that's what's been happening, and we're seeing the court rectifying that and sending a very clear message when it comes to the free exercise of religion. I mean, it's one thing to have a belief, but you got to be able to act on it. And that's really where the rub has been in the last few decades. Lea Patterson, I want to thank you for joining us. And again, congratulations to you and First Liberty for another job well done.
Thank you so much. It's a pleasure to be with you.